Mr. Roper was not inducted into the use of the machinery which he was using. Is that correct?
That's correct.
Why was he not inducted?
He refused the induction when asked and left the production office. The security was in place when I left that position.
If the security wasn't in place, whose failing was that?
Mine.
Some matters which were raised with me over the lunch and adjournment, which before we return to the case, I'll just touch upon. I'm aware that a number of you here are consultants whom will provide reports in the same way that Lisa's given her evidence today. And in particular, you'll note from her evidence that she made an admission to the effect of that the book stops with her, which, if this were a proper trial, would have probably been dissected and opened up to a lengthy cross-examination. So where does that leave you as consultants? Well, this business is all about displacement of risk. A company, when you think about it, and forgive me for teaching you to suck eggs, comes to you to provide a report about their business because they want to displace the risk which they have onto you, so that you as a consultant provide a report and then they can act upon it. Once you've provided the report, you don't want to keep the risk with you. You need to displace the implementation of that report risk back to the company who have instructed you. Now, do you need $500 an hour lawyers to do that? No. Although Gavin's $499 an hour, so you can probably come to him. The best way, law is common sense. You know, a lawyer will always self-justify their own existence. And yes, if you're a part of a business and your risk is great, you should always get legal advice for it. But probably the best analogy to draw is any of you who've recently bought a house. Look at the survey report. Look at the way in which the surveyor makes sure that the report is just what it is, a report and nothing else, and that how he or she then displaces all the risk back to the purchaser of the house because he wasn't able to look into the septic tank or didn't get up into the loft or whatever. So your client care, your retainer as a consultant with the company, needs to be accurate and precise. Client cares and retainers are often overlooked because you get the instructions to do a report and you think, oh great, 5,000, 10,000, 300 pounds, whatever. Some elements of reports are always going to be a cut and paste because it'll be rehearsing legislation or known good practice and stuff which you can get from Tinterweb. But the nature of a retainer sometimes needs to be thought about as to what you're accepting as a consultant. And if you're the company and a consultant sending you their client care letter, you need to read it properly and say, hang on, I want this report to be more than what it's worth, and no, I'm not having you displace the risk back to me. I want this report to be meaningful. So that's something which you may need to look at in the way in which you conduct your business. Otherwise, it's also another thing, it's easy to look at this in isolation. I was talking earlier about RIDDOR and about the old rules, where effectively you report so much. Now the rules have changed, depending on the nature of the injuries, you all know, fractures, apart from certain parts of the bodies, unconsciousness, burdens, 10% of the body, all that stuff. It's not just about your obligations under RIDDOR. It's also about your insurance policy. Whatever your statutory obligations may be, and whatever you are advising as consultants about someone's statutory obligations, it may well be that your client, your company, has an insurance policy, and no doubt it will, which actually will have clauses within it which expect more than merely the insured to fulfil their statutory obligations. They will expect a full accident report, otherwise your insurance isn't valid. They will expect something akin to a RIDDOR, even though it doesn't necessarily fit in with the statutory obligations. So if you're doing reports, or if you are a company, it's important to look at how far your insurance policies goes, what your obligations are as a company, or if you're a consultant, make sure that you are highlighting to your client that they may well need to check with their own insurers as to what their obligations for their insurance policy to be valid is. I know that may be a bit of a digression from the case. It was something which was raised to me over luncheon, so I just thought I'd just put it up there for you all to consider. Mesh, who have I got left of live witnesses? Who's here in reality? Who's coming? Sorry, I can't hear you. Mark Roper. I'll call Mark Roper. This is at page 93, 94 of your bundle. Depending on which bundle you've got.
Mr. Roper, keep your voice up, please. Direct your comment to the learned judge and repeat after me. I do solemnly and sincerely declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Roper.
Could you give your full name to the court?
Mark Roper.
Now, Mr. Roper, although I'll be asking the questions, I'd ask that you direct your answer to the judge. And if I've asked a question and you've answered it, just because I haven't asked another question doesn't mean that you haven't answered it. It's because I, out of the back of my head, are watching the judge's pen so that he can have an accurate note of what you're saying, unlike Mohammed did this morning. Okay?
Yep.
Is it correct that you have a diploma and degree in event management?
That is correct.
You are employed at the moment by MR Events.
I am.
How long have you been employed by them?
5 years.
And how long is your overall experience in event management?
10 years.
In 2005, were you tasked by Chris Woodford to do anything?
In 2015,
2015, so forgive me.
I was tasked to work on a project for Duck Drinks.
What was the project?
It's to launch a new drink.
And what was the nature of that project? How did you go about it?
I worked with a product manager from Duck Drinks to design and deliver the event.
As a result of that, did you come across Lisa Hugh?
I employed Lisa to take on the health and safety side.
Did you have discussions with her?
After some discussions, it was agreed between Miss Hughes and I of a cost and the documents that she would be expected to produce.
On the 15th of November 2006, is it correct that you had to travel to work by public transport?
That is correct.
Why was that?
Because I don't have a licence. That's how I travel.
Did you have a conversation with the project manager from Duck Drinks?
I did.
What was the nature of that conversation?
He wanted a few changes made to the site plan.
Did you agree with those changes?
After some time, we came to an agreement.
Next page. Were you involved in the briefing of the staff in relation to the changes?
I was.
Were you at any time approached by Lisa Hugh?
When I first started when I first started briefing about the changes, yes.
What did she say to you?
She asked me to take an induction.
What did you reply to her?
I said I would do once I'd finished the task that I'd started.
Did you finish that task?
No. Sorry, as in the briefing of the changes, yes.
Then what did you do? Second paragraph down,
Yeah.
page 94.
I went into the field near the production office to implement some of the changes.
How did you go into the field?
I used a buggy.
When you went to the field, did anything happen?
I collided with a member of staff.
How did the collision come about?
As I drove around a blind corner, David was right in front of me, right near. I didn't have time to stop.
What did you do then?
I switched off the buggy, saw him on the floor in pain, and my mind went blank, and I was in shock. I did nothing.
Did there come a time then that you were introduced to a health and safety inspector? Next page.
Later, during the same day, the inspector was introduced to me by Lisa.
What did the inspector do?
He asked me a lot of questions and took a statement.
Did you then have a conversation with Lisa? Did you then, what did Lisa do in relation to the induction?
After the conversation, she,
Middle paragraph.
right, she, after the conversation, the initial conversation about the induction, Lisa did not approach me again about having the induction.
Did you ever receive any communication from Chris Woodford about it?
Negative. No, I never.
Were you aware that the company had a health and safety policy?
I was.
Did you know where that policy, did you ever read it?
No, I knew we had one, I didn't know where it was.
Had anyone told you to read it?
Lisa had told me that I should read it.
Had anyone checked that you'd read it?
No.
Did you know that the buggies came under that policy?
No.
Had you ever ridden buggies before? Next page.
Yes, I had.
Were you ever familiarised with the site? Or you can make it up.
Yeah. Well, yeah, yes, I was familiarised because I was working on it daily.
Had you designed a traffic management system?
In conjunction with Lisa.
What was the priority of that traffic management system?
To try to avoid pedestrians and vehicles colliding. To avoid crossover.
Was there any policy in relation to banksmen?
Not that I was aware of.
Thank you, if you'd like to wait there.
Got drinks. Got drinks.
Yep.
And then if you're thirsty, you could give a duck. That company, is it? That company? Quackers about your drinking? Come on, I'm working with the material. I've been told it wasn't funny enough. What's wrong idea with that, really?
Well, I didn't want to be drawn into something. Eh?
You're nervous. Now, Mr. Roper, just to remind us all, you're the production manager,
That's correct.
and you've been there for 5 years.
That's correct.
And at no point in time have you ever read the health and safety responsibility section of the, or have you read the health and safety manual at all?
No.
You've never read it. How long have you been working in the industry?
10 years.
Do you think that might be part of your responsibility?
Never ever been pressed on it.
Never,
But I was never pressed to.
never pressed to. You were never pressed to do something that is part of your role and function. Do you have the trial bundle in front of you? You turn to page 57 in yours. Page 58 of it. What is the heading of section 2?
Production manager.
Was that your role
It was.
and you didn't do it?
I haven't seen this.
Are you aware how important it is and how serious MR Events Limited take health and safety?
Yeah.
You are? You're with us still, that's all right. And you're aware of their policy, whether you read it or not?
No, we weren't made aware of it.
You weren't made aware of it. You're the production manager. You're responsible for people. You should be actually making this of your own volition to be reading it, shouldn't you? But you chose not to.
This material was never made available.
You turned up on site, spoke to Lisa, I think you're calling her. That's Miss Hughes, isn't it?
Yeah.
And you told her that you wouldn't undertake the induction. Why?
I didn't say I didn't have to. Didn't have time at that particular time that she mentioned it.
How do you know that the induction has been created because of the requirements of the risk assessment?
Yes.
Had you seen the risk assessment?
Yes.
Had you okayed the induction as part of that risk assessment?
Yes, I had.
Had you seen the induction?
I walked through when it was happening.
Again, if you turn through, you can find it set out. It's at, forgive me, it's at page 33, 32, I think it was. Series of PowerPoint.
32.
32, 33. Just take a minute, just go through those PowerPoint slides. Just one straight question. Do you recall those PowerPoint slides? You okayed them, Lisa, didn't you?
We agreed them together, yeah.
Yeah, so you read them, you'd agreed them, and you knew what they contained. Yes?
Yep.
Let's turn to the site plan. Do you have a copy of the site plan, please? It's exhibit 3, we haven't got it, it's page 42, 43. Got it? You arrived at the site and you went to the site production office, correct?
Correct.
Where was this buggy parked?
Outside the production office.
How many buggies are there?
About 3.
Sorry?
3.
3. Were all 3 of them there?
No.
How many of them were there when you got there?
2.
So one's back somewhere else. Were you aware that there had to be security on the site?
Yeah.
Are you aware that the company, MR Events, your company, had employed security to ensure that no unauthorised personnel got onto the site?
Yes.
That contractors were properly badged and accounted for?
Yes.
And that vehicles going into the field had to be accompanied by a banksman? Yes?
Yes.
Yeah. When you went onto the field, were you stopped by the security company?
No.
Why not?
I'm not sure.
Did you see or did somebody or anybody shout at you to stop?
No.
Any security get involved?
No.
Were you checked at any point in time before, when you went onto the site?
When I came through from the public entrance.
You were checked there?
Yeah.
Anywhere else?
No.
Were you aware that you would be stopped by security from entering areas where you had to have a banksman unless you had a banksman with you?
Yes.
And did anybody stop you?
No.
Thank you.
Can I just ask you a question, Mr. Roper? Could you have a look back at page 32, please? This is the site induction. Have a look in the bottom left-hand corner, vehicles. Only authorised drivers permitted to drive. Were you an authorised driver?
No.
Only licensed and trained drivers permitted to drive. Were you a licensed and trained driver?
No.
All buggy drivers must be licensed and trained. That follows that you weren't. All vehicles must have a banksman. Why didn't you follow what you say you knew about?
I would have expected to be challenged once I got to the point where the banksman was needed.
So you weren't going to obey the rules unless someone challenged you, is that what you're saying?
Yeah.
Mr. Campbell?
There's one question arising out of that, Your Honour.
Yes.
As a non-licence holding individual, what was there to stop you from picking up the keys?
Nothing.
What was there to stop you from driving the buggy?
Nothing.
Thank you, that's all I ask.
Thank you.
May you return.
Thank you, Mr. Roper.
Now, ladies and gentlemen, as you may remember, I indicated that there's evidence which comes from the witness box and evidence which is read. And I'm now going to read to you, which is at page 97 or 98 of your bundle, statement of Mr. David Boom.
Mr. Collett, you don't seek to challenge Mr. Boom's evidence?
No, it's not here.
Thank you.
Well, they've never heard a statement read. Yeah. Okay, I'll do it for 4 pages. Yeah, as we want to hear from the defendant, we'll do it quickly. What happens at the court when there's something which is agreed, but isn't agreed in the facts? This is where you want a statement read. The purpose of this statement is to show that there is the injury and what happened. You'll see the preamble at the top. This statement, consisting of 3 pages, signed by me, is true to the best of my knowledge. It's made under what's known as Section 9 of the old Criminal Justice Act, 1967. If you're a witness in proceedings, this is the statement you will make. And that is the preamble that you will sign. Yeah. Yeah. Sorry? Yeah. Sorry? Yeah, I'm just going to read I'll just deal with Section 9 itself. And you'll see at the top it says that if it's tendered in evidence, I shall be liable to prosecution if I have willfully stated anything in it which I know to be false or do not believe to be true. This is the statement which you will make as part of any criminal proceedings. You might find that if you're dealing with civil proceedings, there'll be a similar recital to it, but that shows the importance of the statement itself. And what would happen is that the prosecutor or the defence would read that statement out in its entirety, and when it came to the judge reviewing the evidence before a jury was sent out, he would tell the jury as a matter of law that they are to accept the contents of that statement as if it was true. And so that's the importance of that. Sorry, what page is Matt reading? 88. Turning to page 88, there's also another one, statement from Matt Greaves. You'll see at the bottom of that statement, again, we're not calling the evidence. He walks onto the field after the briefing and starts patrolling. He sees a buggy driving on the field without a banksman. He starts walking towards it. It's about 50 feet away when he saw it collide with a person standing on the field. He sees the person fall to the ground. You'll note that he also gives, prior to that, details of the way in which the field was done. He notes that it was serious on the next page. And more importantly, he says, I didn't get an induction from the health and safety lady when I arrived on the site. The only information I had was the briefing given by my supervisor. And then importantly, he says, I don't drive buggies on the site. I either walk or get a ride from one of my supervisors. For the purposes of today, ladies and gentlemen, that closes the prosecution case. I don't know whether you want to vote. See where we are. Oh, it's getting better.
We wiped the vote. We're now starting a new vote.
We start a new vote.
Yes, so if you want to vote now, please.
Yeah. If you want to have another vote, you can. Ooh.
Have you brought it over that mattress?
Gavin's downloaded the app 35 times.
Go on. Going down.
Yeah, any questions about the prosecution case or anything which has arisen?
Sorry, David, can you just confirm admissibility of evidence?
I can't hear you at all.
Sorry, admissibility of evidence.
Admissibility of evidence. If you'd asked me 5 years ago, yeah, it'd be very easy. There are strict rules about evidence, but those rules are getting more relaxed the more we move on. Because there is an overriding objective in the criminal law, and that is to acquit the innocent but convict the guilty, for want of a better paraphrase, and punish the guilty. That basically allows judges discretion to lead in a lot of things, providing it can be challenged by the defence for a jury to make up their mind as to whether they believe the accuracy of something or not, or that it doesn't in any way undermine a fair trial. The importance of it from your point of view is this. In the past, many company employees, consultants, etc., would be called to give evidence, to produce notes and to produce documents and then be cross-examined on them. Nowadays, the admissibility of documents is widespread because of the sheer prevalence of electronic media and other such things. It's very important, therefore, that actually that you keep records accurate, as contemporaneous as they can be, because they can be used at a later date and they don't necessarily need a live witness to produce them. But they can often show that a company has adhered to everything because the documents show it. The obvious question in this case, which I will ask him in due course, is that, you know, why didn't you have some sort of policy that you had made sure everyone signed that they read the health and safety policy? You know, like if you're working and you've got that thing about do you sit correctly in your chair to make sure you don't get carpal tunnel syndrome, or you get headaches because of your computer screen, and you have to sign off on it as an employee. That's an employer displacing risk to an employee for them to say, I've done the training because I sat there and watched the DVD, and every year it's updated and reviewed. Here, you can see the nub of this case. He has all the policies in the world, but nowhere to show any third party that the policies have been followed, and therefore is at the whim of what people say factually. And that's why he ends up in court. Was if there was an audit trail to show that he'd actually discharged his responsibility, he would never have got to court in the first place. It would have been stopped because he would have been able to show it. In this case, he can't show it. Indeed, the documents actually prove otherwise because of the fact he's abdicated his responsibility, you may think, at the end of the day. Evidence, if you're taking notes, if you're investigating inside your own company, or you've got minutes of you having a health and safety discussion, when the minutes are drawn up, circulate them to everybody who's attended, ask them to confirm that they are a true and accurate reflection of what was said, so that you as the boss can then, if something happens, say, this is what happened at the meeting. Everyone who was there has confirmed that those are true and accurate, and I did cover it. Likewise, if you're doing your own investigation and you're talking to someone, give them an opportunity to check that the record of which you're making of the conversation you had with them is accurate. Again, because it then gives you resilience if third parties or insurers or anyone else like that then gets involved. So that sort of thing, to make sure it's accurate. So yeah, that's probably all I'll say in mesh on that. Okay, Gav, do you want to call your case?
Well, two things, firstly. One, when you're writing reports, tip, I do a lot of work with experts. When you write a report, something David was talking about earlier, put your appendices in the same order as far as you can, so that you know that how great I am TV is Appendix 1. You know your terms and instructions are Appendix 2. You know that the company background is Appendix 3. The reason being is when you're sat there or stood there giving evidence, you know exactly where each one is without having to look at it because it's the standard format. As you get further into it, it's going to be more sort of site-specific and more case-specific. But try and have the same set of first appendices. You can have to make life easy for yourself. If you mix it all around, that's why it's a good to have like a company standard approach to things so that you know where you're looking for a document. Next point, I could be really mean here because I would not be calling you on my client.
No, I wouldn't if I was you either.
No. Unfortunately, somebody tells me I've got to. So, Your Honour, with your permission, I will call my client, Mr. Woodford.
Mr. Woodford, would you like to come into the witness box and face some hostile questioning?
Is that your name?
Yes.
And that's where your signature should be as the managing director, yes?
Yes.
As MD, this is your health and safety manual, yes?
Yes.
Next page. You read this?
Yes.
When did you read it?
I can't remember off the top of my head.
In relation to the incident in February of last year, when do you recollect having read this document?
Probably when it was originally written and produced, which was 6 to 7 months before the incident.
So you did not refresh yourself from the contents of this document prior to each and every event you were involved in. Is that correct?
That's correct.
Did you ensure that any person who you were seeking to delegate responsibilities to refreshed their memory from this document before each and every event?
No, that's why I bring Lisa in.
When did you envisage reviewing this document from when it was first published?
When my safety consultant tells me it needs reviewing, I take their advice.
But people only give advice when they're asked for it. When did you have timetabled or scheduled a review of this document within your own practices as a managing director of the company?
I hadn't.
You didn't.